Hello, this is Sinta Ebersohn from Fair Divorce, chatting to Errol Goetsch today from the Justice and Reconciliation Centre, and we're continuing the conversation about fair divorce and unfair tactics. Errol, welcome and thank you for doing this.
Nice to see you again, Sinta.
We were talking about the windmill effect and the research that you've done about the tactics. Just to give a bit of background, it's an interesting name. Why did you use that name? Where does that come from?
It comes from two places, Sinta. A windmill is a particular strategy on a chessboard. Mm-hmm. And involves pinning somebody down whilst you remove his or her assets. So often a protection order or a criminal accusation pins down a mother or a father, mm-hmm. preventing them from protecting themselves or their children. And also, the windmill is what we see on a farm. So we think of a windmill, there's a structure, there the blades spinning as the hot air travels. And the thing is, false accusations are wind, hot air. All they are is hot air. Mm-hmm. But the legal system is designed to capture even false accusations and to spin the wheels. And then each blade in the windmill is a step in the litigation strategy. The false accusation, the protection order, the denial of contact, the sabotage of mediation, the grooming and the coaching the children to lie, then you bring in the hired gun, you get the ambush report, you present the ambush report in, for example, the Rule 43. Out of that, you get a one-sided settlement. You take the case to the family advocate. These are all steps in a litigation strategy. They're all blades in the windmill, and all of them are being driven by hot air, by false accusations. And here's the thing, even though hot air is, false accusations are immaterial, they are invalid, they are untrue, they still have the ability to drive the system and to destroy somebody. So yeah, that's where the picture of a windmill comes from.
Interesting. I have this image of a windmill with the blades turning and somebody standing on the ground, and I see this blade coming around and just literally knocking you over, and just to get up, the next one comes and knocks you over. So I have the image of it just knocking you.
Exactly what it is. And the thing is, in practice, and what I mean in practice is that the poor target is busy reacting to the previous blade that knocked him or her down, or sliced him apart. And whilst they're busy reacting to the previous blade, the next blade is coming.
So it's important to actually take a step back so that you can see the big picture and actually realize what's going on.
Absolutely. So it's almost impossible for people in the heat of the moment to step back, because they're so busy reacting to, they've just been arrested, for example.
Yes.
You're sitting in cells. How much space do you have to peruse the big picture? So many people then are so trapped by the individual event, and it becomes impossible to look beyond that. And also, many of us are reactive people. Very few of us are proactive, big picture people. So sometimes the way that we operate is actually in the way of understanding what's going on. I've got to say is that if you look at our 100% of the JRC's clients, or 100% of the victims that we've seen in these windmills, I would say 80 to 90% of them have a detail focus. Good memories, they're very attentive to events, but they tend to drill down. They tend to look at the facts in front of them and not always see what's going on. The good news about having a model like the windmill, it's a descriptive model. It tells you what's going on. It's a predictive model.
Yes.
You can tell what's coming next. Mm-hmm. So, for example, if someone happens to just have had a protection order served on them that denies them contact with their child, they now know that the next step from the alienator's point of view is to abuse primary care, abuse contact, and groom and coach the child to lie, so that then the hired gun can be brought in to create a false voice of the child.
Yes.
And so, you know what's coming. You can start predicting things. You can start stopping things before they happen. And importantly, and this is what lawyers, this is why it's important for lawyers to know about this, is that lawyers know that these types of it's called them power struggles, custodial battles between the high conflict person, the person who's aggressively trying to eliminate a co-parent,
yes,
and then the person with a defensive posture, the person who's trying to react and defend himself, herself against these attacks. A litigation lawyer will tell you, you never win on the defense. So if you are experiencing a windmill and all you do is react to what's coming, you are guaranteed to lose. And the best lawyer is also, you can spend the most amount of money on the best lawyer. You will lose as long as you're reacting against yesterday's blade.
Yes. Yeah.
Because
very
tomorrow's
well.
blade will kill you. You need to actually be able to predict, and you need to be proactive. And also, you need to prevent the damage before it happens. So, for example, he or she gets the protection order, starts grooming, coaching the child to start alienating. Unless you stop that, unless you stop the contamination of the relationship, unless you stop the poisoning of the child, it's going to happen. And then the poisoned child will hate and reject the target. And then the whole sort of, and then the social worker will quite rightly say the relationship is broken. The child must be supervised or some way withheld from the target. You've got to stop the contamination process, because if you don't, then that social worker's report will be held against you.
Yes, it's going one way for sure. But the $1 million question is, how do you stop it? Let's say you've just received a protection order. It was just served on you, and you know this is based on false accusations. What do you do?
Well, there are some natural reactions, all of which fail. So our knee jerks tend to let us down. So sometimes, let's say it's the most common scenario. We have a high conflict mom looking to eliminate the dad. It's for whatever reason, that's the common pattern. So mom went to the court. She cried tears. I'm in fear of my life of that man. She walks out with the protection order. She dances for joy. Now she's getting what she wants, and he gets served that evening with the protection order. His natural reaction is to either ignore it, which means that he might very well land up in jail and it's game over for him. His natural reaction might be to bellow with pain and anger. How dare you do this? I, in fact, am the victim. You have been abusing me for years. You're the one who's been doing all this stuff. How on earth can you get a protection order? So he bellows in anger, which she then translates into, you're scaring me, you intimidate, you're threatening me, you're verbally abusing me, and voila, he gets arrested for breaching the protection order.
That's right. Yeah.
Okay. So the fighting doesn't work. The flighting doesn't work. Okay, so he's got some money. He sells the house, or he borrows money from his father, and he puts a deposit down on a lawyer. He tells the story to the lawyer, and the lawyer says, "Oh, it's a protection order. Don't you worry, I'll sort this out when I get there." Very, very unfortunate piece of bad advice. Okay. Because what's happening is that the period between then and the hearing is being used to alienate the child.
Yes.
So waiting for the hearing is allowing the alienator to get away with it. Also, it's most likely, or the lawyer says, aha, this accusation is so trivial, so false. For example, the accusation might be, my child is scared of you. You said something. Okay, now I have a protection order. Says, oh, that's nonsense, that's trivial. You'll easily disprove that. So don't you worry, we'll sort this out at the hearing. Well, that doesn't work, because if it's a false accusation that's easily disproved, at the hearing, that person will say, I can't make it. I'm changing my accusation. I'm changing my counsel. well, let's kick this down, the can down the road for another 2 or 3 months. So the postponement is granted.
So it's buying time to alienate more.
For the alienation to happen. Okay. And so going to a lawyer who is unversed in dirty tricks does tend to elicit bad advice. And the normal responses of an attorney to say, let's sort this out at the hearing, that turns out to be a bad advice because bad stuff is happening in the background. So if the normal things don't work, what are the abnormal things to work? So the unconventional responses are to immediately call a family conference. Okay? Now that's unconventional. It's in the Children's Act. They call it a family forum. Section 70, Section 72 of the Children's Act. It's there. Okay. But it's the beginnings of a mediated or non-litigated process. And here's the thing: it's easy to lie to a domestic violence court. It's easy to get. It is horribly easy to get a protection order, an interim order, based on pure fantasy, because the target's not there.
Yes.
Okay. You can say whatever you like on a piece of paper. The other person's not there to deny it, and you can get your protection order based on your spurious statements alone. Okay? But the family is not so easily fooled. They know who has been hitting who. They know who has been doing what. They know who has a reputation for being a psycho.
Who do you include in that family conference?
Well, this is where African customary law gives us such good advice. You look for the elders. It's a discussion between the elders. So when we help people in these situations and we divert it from court, we say, who is the oldest, the most senior person in your family and in the other side's family that can represent the both parents free from stuff. Okay. Yes. So typically, often it's a grandmother or a grandfather on both sides. But when we do family conferences, it's absolutely everybody. In addition, we video the family conference and we say the contents of this video will one day be shown to the children. So don't lie, demonstrably act in the children's best interests, because what you would like is that the content of this discussion is shown at their wedding one day as an example of why I love my mom and my daddy, why they were wonderful to me, why they worked together, and how they overcame issues. But when it came to the crunch, I can trust them because look what they did for me, and here's the proof of it. So often, even obviously we're dealing with those high conflict cases where somebody has a disorder. And you heard me say in our previous session that I have great sympathy for that person. So how do we help everybody, both parents, to be the best parents that they can be? Yes. Now, very often a person with a disorder has a need to look good.
Yeah.
And the way to make someone look good is to require them to act in public, in front of their family and their friends, in front of the children, in sunlight. It's when that person can go to a lawyer secretly and say whatever they like, or go to the domestic violence court secretly and say whatever they like, or go to a social worker or psychologist secretly and say whatever they like, in the expectation that they will never be challenged on what they said. It's secrecy that helps the alienator or the liar get away with it.
That's true.
A conference is a very good way to bring transparency and balance. Okay. Now, we very much like the involvement of grandparents.
Errol, can I just ask a question before we continue with that? How do you hold a family conference if there's a protection order hanging over somebody's head?
Welcome to Zoom. Welcome to the world of Zoom.
Okay, great. Yes,
Okay.
fantastic.
That's okay. So, and the thing is that if there is some absolute constraint on presence, say dad is locked away in some way, but his parents can speak for him.
Yes.
And the good thing about having parents speak for the child, okay, is parents are often balanced, not always, but often. They often know the facts of the case. They know there are some of their daughter's strengths and weaknesses.
Yes.
But they are driven by, how can we make this work, because there are grandchildren that we need to look after. So often grandparents have their heart in the right place, the kids, whereas very often the parents can get self-centered and the involvement of lawyers can make the process adversarial. So we're really talking about shifting from the adversarial litigation, sometimes lawyer-driven process, to a family-driven, consensual, and transparent process where it doesn't matter what you did in the past. How are you going to work together in the future for the balance of the children's childhood to make them the best kids they can be?
Yes.
So we are going, for example, right at the moment, and we start off with a very adversarial situation that have been going on for years and years and years. It's a situation that came to the head because family members had to break into the house to rescue people. It was that bad. But now we've got a family conference-driven process, and we haven't allowed anybody to bring accusations from the past. It's not about the history, it's about the future. And both parents have transformed. Both parents have a lift in their step. They have a light in their eyes. They're totally focused because they understand they're not being blamed for the past. They've been given the opportunity to design the future, and they're so stepping up. So yes, so these are unconventional responses, and here's the trouble: is that the conventional response to a high conflict personality is to lawyer up.
That's true.
Which absolutely guarantees an expensive, drawn out, bitter conflict through the legal system, which is, I'm trying to say, guaranteed to leave the children at extreme risk. And it's also almost guaranteed to ensure an unhealthy outcome that leaves the children with the parent who was most willing to fight viciously. In other words, the least healthy parent. Okay, so we want to actually switch tracks from litigation to mediation. And the common model of mediation is a mediator who works for the common interests of both parents. It's a beautiful model in the best interest of the child. But there's an alternative model of mediation, which involves the family and the family forum. And I really recommend that people explore both options and involve as many family friends together as for transparency and for accountability. I also want to now talk about the special role that grandparents have. Grandparents in South Africa are, I believe, badly treated by the law. Grandparents have a financial duty of maintenance if the parents can't pay their way. So if dad can't pay, dad's parents are liable to step in. So there's a duty on grandparents, but there's no reciprocal right of grandparents for contact.
That's very true.
I believe it's unfair. I believe it's unconstitutional. And I also believe that it's a deliberate malice in the Children's Act. So I have a concern that the elements of the Children's Act were shaped, were warped, were twisted to suit vested interests. And the lack of a contact right for a grandparent means that people with a vested interest in removing children for sale into adoption have a much easier stab at it, because they can remove the child if mom or dad are in some way discredited.
Yes.
And they can remove the children from the grandparents as well, because grandparents don't have a vested right in the Children's Act. So I believe that's an area of reform. And it might be a challenged area of reform because there is money in the adoption industry. There's money for removing a child. So what we do is to restore the rights of the grandparents and to recognize the authority of the grandparents. We bring grandparents into the family forum, into the conference. We bring them into the parenting plan. Because now we are trying to switch the whole divorce away from a sole custody play involving false accusations, playing its way through the court system. We're trying to transfer that to the family conference, the family model of arriving at 50-50, with grandparents on both sides getting rights of contact as anchors, as stabilizers, and to make them guarantees, to make them guarantors of the survival, the strength of the parenting plan.
Yes, and then it's a family matter, which is what I've always believed it should be. And I imagine it also automatically almost creates a very healthy and wide support structure for everybody that's involved by bringing them together from the start.
So one of the misnomers of the Children's Act is the belief that, or is the over-reliance on Section 7 and Section 9, the best interests of the child are paramount.
Yes.
It's a beautiful system. It's a beautiful sentiment. I don't think anybody can challenge it. The trouble is our adversarial legal system has detached Section 7, Section 9 from Section 2. The opening words of the Children's Act declare that the objective of the Act is family preservation. Family preservation.
Yes.
If you uncouple best interest of the child from preservation of the family, then you're not seeing anymore, like we do, you're not seeing anymore that the child's best interests are served in a happy, safe family with strong bonds with both parents. Okay, if you decouple Section 7 from Section 2, then you can be an adversarial lawyer and you can say the best interest of this particular child is served if that target parent is eliminated. So uncoupling Section 7 from Section 2 opens the door to alienation and adversarial process. But switching from litigation to, and the whole polarization and anger that goes with that, and switching to a family-based or family conflict-based mediation model, it restores the family, it preserves the family, it does 100% what Section 7 is supposed to do, restore the family and to make the child as safe as a child can be.
That makes sense. Yeah, that makes perfect sense. So we've talked about this now in quite, what's the word I'm looking for? My brain is frozen. Extensively. That's the word I'm looking for. Sorry. There are other types of windmill tactics that you have. Would you like to tell us more about those? And maybe share some, if you can, share some of your own experience or case studies that you can?
I'd say that there's a windmill for a situation. So the domestic violence windmill is the use of accusations of violence, which are taken to the domestic violence court in order to use a protection order to shape the eventual divorce outcome.
Is there a domestic violence court, or does it go to the criminal court?
There is a domestic. So what happens is the first applications go to domestic violence court. Breaches of a protection order go to criminal court.
I see.
Okay. So theoretically, you can have both courts in operation to shape the divorce outcome. Now, if you are a man and you have a son or you have sons, you are at risk of a domestic violence windmill.
And why is that?
Well, because the favorite one is the molestation one, and that's normally unavailable unless you have a daughter.
Yes, I see.
Okay. So a father with sons expect a domestic violence windmill. A father with daughters expect a molestation windmill.
Yes.
So how does the how does domestic violence will operate? A fight gets staged. Let's say she hits you for days and weeks and months. Finally, you snap. You say something like, "Don't hit me, you nasty woman, you." That's enough to get a protection order. Goodness,
it seems so ridiculous, actually.
So I would say that. So it's we have an unbalanced system. Okay. So because it's so easy to say, I am in fear of a subjective test. I'm in fear of.
Yes.
Hasn't done anything yet. I'm in fear. Okay.
And that is enough.
So some magistrates have wised up and they really have closed that loophole down. But there is a terrible weakness in the Domestic Violence Act, not just the introduction, which is so gender biased. It's a child, the woman and the child against the man. But the Domestic Violence Act has nowhere in it a statement that it is perjury to lie to get a protection order, which is a terrible gap, a terrible absence. There is a constraint about lying to the police to get the warrant of arrest. Okay. But it's a pointless constraint because the warrant of arrest comes automatically. Not if you lie to the police, you get the warrant of arrest. It comes automatically with the court process. So it's a useless protection in practice. I see. And there's nothing in the act that says that it's perjury to lie to get the protection order. That makes the domestic violence court so prone, so vulnerable, so open to the most malicious, vexatious, fraudulent, fictional statements. So that's the domestic violence windmill. The molestation windmill is different, okay? And it'll go to a different court, but it can also be triggered by the most spurious of false accusations. Okay. So we have seen applications which are triggered by, he looks at my daughter funny. Goodness. Okay. Or he baths with his daughter. Or they stand in the shower together. Or he doesn't close the bathroom door. And the point is this, is that the statements themselves are not where the action is. Okay, so you can go to so the most common way is to approach a social worker. Okay, you take the child with you and there's a girl and you make statements on her behalf and you tell the social worker that there is a threat to the child. Social worker scripts. Who wants to have a threat to the child? Yes. Okay. And we're obliged to protect them. Yeah. Social worker puts a call to a police station or the DSD, okay, or the court, the children's court. And the social worker calls for some sort of block on daddy's contact. Errol, is this also because they have mandatory reporting that also puts them in a position where if there's any suspicions, they have to report it, eh? Well, it is true that about 22 professions have mandatory reporting requirements. However, social workers in private practice who are used for these sorts of games do not, as a rule, put in reports to those institutions. They're more in the game of private activities. Okay. So what happens is you then go to a social worker, and let me not say that every social worker doing this is in some way a hired gun. Many social workers are fooled. Let's call it that emotional capture. They honestly believe that they are protecting the child. They have no idea that they are the victim of stunts, of staged events, that theater is being played out in front of them. They have no idea that that girl, that child, might have been coached and groomed for months and years to get to this point. Okay. Yeah. So the social worker then receives a complaint, a report, and acts on it, doesn't check with dad, doesn't verify the facts, doesn't appoint an investigator, okay, just acts on the fear that something might happen. All of a sudden, dad is locked out of contact by who? By a policeman, by a court order, by a prosecutor, the criminal court. In other words, very, very powerful players are standing in the way of contact. It is now, and here this now the prosecutor, the investigating officer have the impossible task of investigating molestation or a fear that never happened.
Errol, can I just ask a question there? If I'm thinking logically about this,
yes.
My mind says to me, for anybody to write a report, they obviously have to at least interview all the parties involved.
No.
And if you're saying they're writing reports without even making any contact with one party, surely they're required to do that. Is this now willful and intentional?
It's both. It's
that
both.
They leave it out, and how do they? They shouldn't get away with it.
So there are professional hired guns who systematically produce reports without involving the third party.
But then somewhere along the line, when that report is tabled, surely somebody asks, well,
oh, okay. Well, no.
Not.
So I'm going to use Ruth Garb again. So her CV speaks about, is it 4,000, 5,000, 6,000 reports in her lifetime. But yes, sweet lady's in her 70s. So she's had the most veteran experience. She has been involved in countless cases, and her norm is to produce a report without the involvement, without hearing the other side. That's how she makes her money. She's available for hire if you want someone to produce a report that isn't corroborated, okay, by the other side. So there are people then who play that game, but and there are social workers who. So what happens is, let's say you're dealing with someone who's not a Ruth Garb, you're dealing with a good social worker. The first thing you do is sort of, how can you trick that person? Well, you present a semi-plausible a threat to the child.
Okay.
That social worker then immediately goes and registers this threat. If the social worker, now I'm thinking about a particular case, if the social worker does consult with the father, he's sitting in jail already. He has already been arrested. He has already been in some way processed as a threat.
Yeah.
So the context of that session is not, are you guilty? Are you the victim of false accusations? Does the accuser have a vested interest in stealing the child from you? Okay. The context is, you're guilty and I'm going to find the evidence against you.
So the whole critical thinking process is skipped, actually. I mean, for anybody who looks at this critically would recognize that something's wrong.
So there I am, and I follow these cases dispassionately. And I had in mind the model of the Children's Act, which lays down a pathway for how these things are handled. And I'm shocked by the procedural gap, the difference between what happens and what should happen. And I understand some of that as hired guns, and I understand the rest of it as emotional capture.
Okay.
People really believe that they're protecting the child against the threat. The social worker herself might have entered into the profession as a wounded healer. My father molested me, so now I'm doing this job. So if then someone says the father's molesting that child, I believe it without question.
Action. Yes.
Okay? Okay. So what happens, and then the third element over here is the failure of the professional bodies to impose procedural protocols for this.
Yes.
And genuine and make offenses out of breach. So social workers and psychologists and lawyers can get away with a complaint to the council that they were involved in producing false reports. So even if you're found guilty, you can still be get off. For example, the Health Professional Council might slap you with a 5,000 Rand fine if you're found guilty of producing a high gun report. Meanwhile, you earned 100,000 Rand for that report.
And you can continue practicing.
Absolutely.
Yes.
So I think we spoke previously about sleepers, about the regulators, the people we rely on for quality control being missing in action.
And that's probably a manpower problem also. And like you mentioned earlier, there's just the total work overload of work that's
also
on these people's shoulders.
It's also a manpower problem. It's also an overload problem. But you know what? It's the absence of, let's go that, of hearing the other side. So if you look at the composition of the oversight boards of the Legal Practices Council, of the SAC, SSP, of the Health Professional Council, what's missing? Customers. Customers are not on the oversight committees. The board of the council for the SAC, SSP, it has, I think, 13 spots there. There's not a spot, a designated spot for the parent, or the client, and especially not a spot for the person who is the victim of a false report or a hired gun report. So right from the top, it's missing the voice of the victim, the voice of the client. So the rules are rigged by the absence of someone who's representing the public. The rules are rigged in favor of protecting the insider from the outside, from the public, rather than protecting the public from the rogue insider.
Yes.
So there are disciplinary procedures, but between you and me, Sinta, having looked at all too many of those cases, at the very, very least, they pay lip service to ethics. And yes, some occasional rogues get trapped. But most rogues have no fear at all of the disciplinary committee.
Yes, it's a slap on the wrist and nothing more than that, basically.
And the thing is, we need to look at the failure of the self-regulation model. Lawyers, social workers, psychologists, they regulate themselves. And the boards are driven by the membership fee for the the fees of the members.
Yes.
Why on earth should they all by themselves take the stand of the side of the public, of the client, against their fee-paying members? So I think the model by which the boards operate, the financing model, there needs to be much more public resourcing of those models. There needs to be freer of membership fees, so they can be intellectually free to consider the other side. And there needs to be oversight bodies that represent clients, who represent victims, to ensure there's both balance in the ethical codes, but there's also stronger enforcement of those codes and no protection of rogues from the inside.
So there's a lot that we can criticize or pinpoint of what is wrong in the system and the way we operate our system. But for the man on the street, there's not much to be done about that. I mean, it takes campaigning and lobbying and a whole lot of work to get those things to run.
To expect the individual to remedy procedural abuses in his own case that require reforming the system. It's totally unfair. So yes, definitely, this is where people need to come together and strategies need to be developed. But I want to get back to what you said about how things look bad. Well, they can, but at the same time, we do have a health professional council. We do have a law practices council. We do have an CSP. We do have professions. We do have a legal system with some wonderful laws, and we have some wonderful individuals.
Yes.
So the elements are there to expect that in the future, children are safe. We also have a Children's Act and the Constitution that really promotes children's rights. So the standards are there. A lot of goodwill is there. And South Africa has some fantastic people. There are just some structural elements that need to change. We mustn't be affected by the high number of terrible cases there's an even larger number of normal cases where things work out well, where all the professionals do their job well. It's just in this particular area of the high conflict case, where there are false accusations at work. The system is struggling with these exceptional cases. And
Errol, a question. Sorry.
So yeah, no, we need to work out something for these exceptional cases, because that's where children are most at risk. That's the 20% of cases consuming 80% of resources. Economically, that's the place to operate. Yes. And morally, that's the place to fix.
Yes. A question that comes up for me when I listen to you is, in your experience, perhaps you've come up with some questions or a way to look at it. If I'm a lay person and I am going through a divorce, or I want to start a divorce procedure, what do I look for? What questions do I ask? How do I know whether I'm dealing with a mediator or an attorney that is equipped to identify these sort of threats if they should appear?
Well, that's a good question. There are very, 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 very few lawyers and mediators who are equipped for those exceptional cases that are characterized by high conflict personalities and false accusations.
Yes.
The system is not designed for that case. So how do we recognize the need?
And again, people are not trained for that.
No, no one's trained for that. So we have clever people who train well, but the curriculum isn't geared for these types of cases. If the curriculum was geared, well, then we wouldn't have so many cases. If the legal system, if the court system was geared to spot and stop these problems, you wouldn't have these problems. They're only flourishing in the way that they do because they are outside of most people's curriculum domains.
Yes.
They're outside of most courts' mandates. They're still between the cracks. Okay. So we only have a problem because the system doesn't have a solution.
Yes. And that's a work in progress. As society changes, our laws have to adapt and change. So
we might have had a legal system that was perfect for 50 years ago, but now it's now.
Yeah.
And the system, and we really have to get the system that in these particular areas, that's good for what we've got. I don't know if 50 years ago we had the number of high conflict personalities that we do today. We seem to have an explosion of crazy.
True.
We all know that lockdown, COVID, economic recession, etc., have affected people's incomes. It's also meant that professionals are tempted more and more to take on cases and to play dirty, because it might be the difference between paying the direct debits this month or not.
Yes. Yeah.
So we need to have something, even for people who misbehave, we don't know what pressures they are under.
Yeah, and it is still a minority if we look at the big picture.
I'm not so sure about that. I would say that there's a bleeding happening.
Yeah.
Because dirty tricks are so spectacularly successful. Dirty tricks that were originated by crazies have now become mainstream.
It's true. It's true.
So I think it's become normal. I'll give you a couple of examples. So you've got what's that Facebook legal page, legal whatever in South Africa. So every now and again, somebody comes on board and says, I want to get divorced. My husband hits me, or my husband doesn't have a good relationship with the children. He wants to come and take them away. What can I do? So it creates this sub story, and it may be true, may not be true. And I looked for what type of advice is generated by those types of calls. Because what somebody is saying is, I want to break the law.
Yes.
I want to eliminate my rival. I want to capture my child. I want to take control and not share. Well, that's very anti the spirit and the wording of the Children's Act. That's rivalrous. Okay.
Yes.
And maybe somebody's angry, or maybe somebody has a personality defect and is scouting for, give me the legal tricks, give me the legalese to get what I want.
Yes.
Okay, so what type of response can you get? Well, typically on this particular Facebook site, which has tens of thousands or even more commentators, within 5 minutes, we're sure to get about 15 messages. Some of them will even be from social workers. The Facebook page will say social worker.
Yes.
And they will show how to obstruct the parent. They will give excuses to play dirty tricks. And there is not, in all of that advice that's given to the potential alienator, the rivalrous parent, none of them will ask, are you healthy? What's your motive for doing this?
Yes.
Have you considered your duty to behave in a co-parenting way? What is the damage to your child to see mom and daddy fighting in the way that you want things to happen? It's a total. So what happens is crazy behavior has become adopted because it's successful. It's become mainstream. And the type of bad advice that you get from the hired gun professionals has now become available. It also has become mainstream. So now you must talk about the intersection between the parenting model, the family model, mom and dad working together to look after the kids, and things like the gender war that we see out there. So now you've got often angry women giving venomous advice to other women just because she's a woman, and not realizing they are feeding a monster. Okay, you get good men, you get bad men. You get good women, you get bad women. And good or bad, or the character, the quality of our character is totally independent of our gender, of our race, of our class, of our sexual preference. So goodness, is something that you must look for and protect wherever it comes from. But if you have a gender-biased activist who either wants to defend men because he's a man, or attack women because she's a woman, regardless of their conduct and their character, then what you're going to get over time is the mainstreaming of bad advice, the mainstreaming of misconduct, and the increase in the number of children who are being abused in the divorce process by people who are spouting legal excuses. So what I'm saying is, you said that it's the exception. I believe that elements of dirty tricks are common in almost all divorces.
It's almost becoming the norm then. And
well,
yes,
So I mean, we can speak about the list of dirty tricks. On the list of dirty tricks is claiming sole custody or primary residence, full stop. To claim primary residence is the first of all the dirty tricks.
Yes.
Because in a fair divorce regime, in a country which promotes equality, in a family model where mom and dad together work together because the child is bonded to both, in that family model, in a healthy country, a fair divorce means 50-50. So when I am upfront trying to squeeze you out and say you are the 2 weekends a month parent,
yes,
you are going to have less role, you're going to have less authority, less contact time. You're not going to raise a child. I am going to be the power player here. That's a power play. That's,
yes, that should not even happen in the first place.
I think you'll agree with me that the dominant demand in every divorce involving children is primary residence.
Yes, yeah, I agree with you full-heartedly. And the starting point
right from the start, divorces are unfair because now somebody is invested in winning primary residence. Well, how? By blaming, by accusing. Yes. And it's a short step from accusation to false accusation.
Errol, are there some famous cases in the world or in South Africa that
Lots.
actually illustrate this. Would you
Okay, so
share some with us?
sure. I think we all know Brangelina. Okay, so we all know pirates of the
Pirates of the Caribbean.
Pirates of the Caribbean. So those
Johnny
are famous
Depp.
cases. Okay, so Johnny Depp was accused in 2016 by Amber Heard of domestic violence. And Amber Heard got a lot of support as a victim. But then his side released recordings where she was admitting to being the abuser. So that could very well be the Amber Heard, Johnny Depp could very well be a power play, a money play based on false accusations.
Yes.
Now, Angelina Jolie. Well, she's done both domestic violence accusation and she's done the molestation accusation. In 2016, she reported Brad Pitt for domestic violence.
Yes.
Excuse me, I'm going to have to go. We were talking about, do you want to start again for your recording?
No, it's okay. I'll just have it edited. You were talking about Angelina Jolie?
Yes. So Angelina did both the domestic violence and the molestation accusation. So in 2016, she accused Brad Pitt of molestation. And obviously a high profile case. It was investigated both by the FBI and the Child Protection Authorities. Both investigated and found that the complaints were groundless. In 2021, she accused him of domestic violence. Both of these fall into their current divorce. So from the outside, they would look like power plays about the windmill. So those are famous cases out there. What's happening here in South Africa? So I'm going to give a couple of cases where people fought their divorce very dirty. And I guess the dirtiest way to play a divorce is to hire a hitman. Okay. And we know in 2010, Shren Dawani, he hired a hitman, alleged to have hired a hitman within 30 minutes of arriving with his new bride, Annie, at the airport. In 2012, John Kotzer, the Muddywater monster.
Yes.
What triggered him? Well, she was divorcing him. How did he respond to her divorce, her wish divorce? Well, he killed her son. He tortured her. He organized a gang rape. So divorce can really trigger a terrible a narcissistic rage in some people. The narcissistic rage was the explanation offered by his defense counsel, Tasha Spannenberg. In 2015, I think it was East London, Chris Paniatu, who hired two hitmen to kill his wife Jade because he was having an affair with Chanel Coutts. And apparently he didn't have enough money for both households. Okay. And then we've had three examples of men. In 2019, Nonhlanhla Matwane, she confessed to hiring 4 hitmen to kill her husband for the life insurance. So those are examples that show that there are some people who are willing to behave terribly. Now, for those who have a legal bent, who actually want to have a look at case studies, law-reported case studies, I'm going to give 2 cases. The one is Caprari versus Du Toit. That's a 2014 case out of the Gauteng High Court. And Barda versus the SAC, SSP, and another. So the Caprari versus the Toy case shows some of the dirty tricks that we see: forum shopping, and forum skipping, moving to another city to invalidate the previous family advocate report and to force a new start, and refusals to mediate. Also, breaching of the court order, contempt of the court order, that would protect contact and the relationship.
Mm.
Okay? The border versus the CSSP and another, to me, demonstrates the willingness of a regulatory body to protect the insider versus from the public, when even when you had a legitimate grievance. To me, also from the outside, it looks to me that domestic violence was used as a power play. And then the particular social worker herself, who had produced a report that was limiting of the father's contact rights. If I remember correctly, she actually was saying that the father should have no contact rights at all, ever.
Goodness.
Sometimes you'll laugh at the reasoning. I'm going, of course, by the public, by the court record. So there may be facts and reports that are not in the court record, but let's go from what we can see. The rationale for such an extreme recommendation was that the man had abused his pet.
His pet?
Yeah, a dog.
Goodness, okay.
Well, it turned
allegedly.
Out he hadn't. Well, it turned out that he hadn't. It turned out that she had entirely misrepresented a non-event to arrive at a predetermined outcome. So how does a hired gun operate?
Wow.
Hired gun operates by I have my template ready. The template says the target should have no contact with the child. My template is ready. You just come in, pay me the money I need, and I will fill in the blanks. Who is the mom or who is the dad who I must get rid of? Well, in the border case, the social worker achieved that. And then the social worker also did something extra. So the social worker was there to create a contact schedule for dad. And if the social worker is absent, the social worker can't produce a contact schedule, which means the father won't have contact rights.
Yes.
So what the social worker did in that case was she abruptly resigned. She writes a report cancelling his rights, defaming him with this accusation about abusing the pet. And then she resigns from the case, denying him a right of reply to her report. Okay. And then leaving him without contact rights because that was her job to create the schedule.
Yes.
So to me, that is classic hired gun. And to me, the sorrow was not that this happened. The sorrow to me was that the SAC-SSP, given these facts, went out of their way to protect the social worker concerned. Okay. And that it turned out that the disciplinary process, as well as having some unconventional features that don't match the enabling statutes, that the disciplinary procedures did not work to hear the other side, did not work to expose the facts, and certainly did not work to apply the code of ethics, because the code of ethics for social workers is very favorable to clients. Okay? It's written in such a way that it gives the client a huge amount of authority and really puts the social worker in a very service position, okay, as a service provider.
Yes.
But the disciplinary committee does not enforce that code as it's written. And of course, the effect is to let rogues off. Now, I remember this first came to my attention in my situation back in 2010, when Ruth Garb caught my eye.
Yes.
And in 2010, you could go onto the website of the SAC-SSP. And there was a list of social workers who were facing disciplinary complaints. At least you could get some sense of, who am I dealing with here? That list of social workers facing disciplinaries has been removed. The client, the public, no longer knows if the person that they are commissioning or the person who has written a report against them is credible. Now you could say, well, who wants to hang out our dirty laundry? Well, clients want to know if they're in safe hands or not. Courts want to know if the reports are credible or not. Then in addition, if the council is going to be limp-wristed and soft-headed about rogues, then at least have protocols to guide the behavior of the professional, so the professional knows what is right and what not to do. But if you ask the council for what are your protocols for reports, the answer is haven't got. No forensic standards. So a council that has been in existence since, I think, at least the 70s, we're talking about 50 years now, has not produced a properly enforceable code of ethics and has not produced forensic protocols to protect clients, have not in fact updated the code of ethics since the Children's Act was promulgated, and has not updated any procedure that they might have to reflect the change requirements of the parenting plan and the duty on parents to consult the co-parent before they do.
Thank you for listening to this conversation. We'll continue this in the next interview, so be on the lookout for it in the podcast and on the YouTube channel. This is Sinta Ebersohn from Fair Divorce. Hope to chat to you soon.